as the trustee. So we have a corporate trustee. Now in Tom's scenario, there can be trust property, so that'll just sit there as trust property. And also we have the equivalent of personal assets. So we have the company's capital or its assets available. In here we have trust property, the same as we do over here with Tom, and a creditor who sues the trustee will first have the trustee's indemnity out of trust assets to pay that debt, and if it's insufficient, then they have the assets of the trustee personally, or in this case the company's assets, which is its capital and other assets. So a company can hold property in trust in very much the same way as a natural person can, and although they legally own it, they don't have the beneficial ownership, so it must be used for the benefit of the beneficiaries. So if we summarize major differences, we could say the trustee is a company, not a natural person. It of course is controlled by its directors, and they sit outside of this. The trustee company is liable on trust contracts, and it has that right of indemnity out of trust assets. So it's very, very similar. The only thing we really need to add in here, of course, is those extra parties that all companies have to have because they can't run themselves, and that is, of course, a director. And then we've got our shareholders sitting in here somewhere. Now this is very much like our previous discussion. So if we were to put a line around here, we can identify the trust structure, our trustee, trust property, and beneficiaries. And we can do the same thing here. And this is useful because it shows something very clearly, and that is that the directors or director and the shareholder or shareholders sit outside of the trust. So a director is not personally liable to the creditors of a trust. The trustee company is. The same way that companies are always liable for their own debts, and directors are only liable if they get sued in a liquidation, typically for reckless trading or such. So directors and shareholders are much safer in this structure than being the actual trustee, which is why it's so appealing for people. Now, some of the problems or differences we need to consider with these trusts, coming back here, is issues. We've dealt with these two issues in a different context, and they're much the same here, but they're just magnified with the use of corporate trustees. The first is that the company may have no money. A trustee personally may have no money too, but people are less likely to go into a situation with no money and risk bankruptcy than a company may take on a role with no assets. The second is the trust deed may have that clause, no trustee indemnity from trust assets we talked about previously. Now let's just illustrate those two situations with an example. So we have our same scenario, we have our director, we have our shareholders, we have our beneficiaries down here, trust property, personal or corporate assets, and we have our creditors we deal with. Now, let's say we add in a few more creditors for argument's sake, and they have supplied goods or services to the trustee, and so the trustee has contracts with them. Now, the first recourse the trustee has is to use trust property, so probably incurred debts. So let's throw some money through there, leaving a little bit of money here. Now, what happens if the trustee runs out of money? So let's get rid of their personal property. Let's say they don't have any, and this money has disappeared. So then we're left with, in this case, this creditor who has a right of action to sue the trustee, Corporate Trustee Limited, and they would seek an indemnity first out of trust assets, which are a bit missing, and their personal assets, which are zero, meaning there's no assets to pay the creditor. What can the creditor do? Potentially sue the trustee company, have it put in liquidation, and potentially chase after the directors. So that's one scenario where the creditors lose. The second is this issue of no trust indemnity. So let's rearrange this drawing just a wee bit, and we'll put our trust property back in here. And we've got our three creditors going. And so normally, as discussed before, this money could be used under the indemnity to pay creditors. But if we have that clause in the trust deed that says you cannot use these assets as an indemnity for trustees, then the only money available to pay creditors is the trustee's own money, in this case the company money. And we can get to the scenario, of course, where that is nothing or next to nothing. So once again, we get a scenario where this creditor or the other two, they can take action against the corporate trustee, but the trustee has no assets this time to seek an indemnity from, and no company assets of its own to pay those debts. Therefore, once again, the dollars available for creditors is zero, and again, the creditors could seek the liquidation of this company with a view to chasing directors, which we know is quite difficult. And this leads us to the next question is, can we actually sue directors? Now, there is one very good case on this which we can use to illustrate the issues. Vance and Levin against Lamb and Simpson. It was a Wellington case in 2008. I'll just draw this out before we turn to the actual case, just for the facts. What happened in this particular case is we had a trust set up, and it wasn't a corporate trust. It's not a trading trust at this stage. It was just a natural person. In fact, there were several people as trustees, and they called it the Cuba Trust. This is in Wellington and Cuba Street down there, so presumably it's got something to do with that naming. Now, that trust was set up for the purposes of a property development, and they wanted to buy a piece of land in Wellington and Upland Road. Specifically, it was 36, which you can see in the case facts. To do this, they were going to have to get some money, and they were going to seek that money from a lender. Now, the lender was a nominee company, but for our purposes, we'll just call it a bank. Okay, so let's put a bank into the situation down here. So the trustee went to the bank, and the bank lent money to the trust, which means to the trustee. And that money was used to buy the property, and the bank then took a mortgage back to cover their security. So let's just put that symbol in there for a mortgage. So very standard arrangement. That means they are paying the bank mortgage payments in that direction. Now, in addition to this, because it was a property development, of course they needed a lot of work done on the property. So let's say builders and plumbers and landscape or earth moving type people. And each of those is a contract that the trustee would have entered into in their capacity as trustee. Now, at the start, there was money. So there was trust property, it was capitalized, and that was all good. And so they could use that as their first indemnity to pay the creditors, as they're supposed to do. So that's as it should be. However, the development was not progressing very well, and they were having difficulty maintaining payments to the bank, and this amount of money was getting smaller and smaller by the day. So they needed to do something, because as a trustee, this person here is going, I'm personally liable to everybody, and since there's very little money left, that means I'm going to have to pay it out of my own personal funds. Now, they weren't keen on this, and so their answer to that was to get the trustee to resign. So that trustee retired, and in place they came back with Upland Nominees Limited. So they changed this into a corporate trustee. So now we have a true trading trust. Now, the reason they did that was to escape personal liability, and that was quite critical in the court's decision on this particular case. However, prior to getting to that, they realized that they weren't going to continue to be able to pay the bank. So what they did is they had a sale to a buyer of this property. The buyer then gave them a big bucket of money, and that money went through to Upland Nominees Limited. At this point, they were able to discharge the mortgage, so the bank was out of the scenario, and they were left in this position with the bank gone. They had some money here, so they could pay their creditors, and all the money went through to there, and the company now had no money left. Now, at this point, they They had cleared most of their debt, but because they'd sold a property and they were a property developer, then part of that money should have been used to pay the GST, the tax payable on the sale of property if you are a commercial investor. So that left one big creditor, and that creditor is the IRD, and they were owed something in the order of $221,000, which they wanted, and of course the company has no money. So the IRD then filed for this company to be put into liquidation. A liquidator is appointed, and the liquidator now seeks an action against the directors. And so we are now suing the directors for breaches of the Companies Act. Now let's go to the Companies Act and just have a bit of a revision here. So we know that under the Companies Act we have directors' duties, and you are also very aware that those come under sections 130 to 138. And so we have powers, act in good faith, reckless trading, and duties in relation to obligations. Now, the case that we're talking here, which I'll put on, and it covers the various facts, and down around page 10 you can see a summary of the actions for reckless trading. And effectively the court is simply saying that they were recklessly in trading because when they took on these obligations they had no money, and it was actually $215,000 owed to the IRD. They also went into the property development with not reasonable grounds that they'd be able to meet their financial obligations. So they breached section 136, and they didn't act in the best interest of the company when selling the property. So they're pretty much liable for everything. Now, what does this tell us? It tells us that you can run a corporate trustee, but you will be liable, as any director will, if you trade recklessly. Now let's just finish off looking at some of the advantages. The major advantages here are flexibility. So you can see the list here. We can change the beneficiaries and shareholders. We can have discretionary rights for our payments to beneficiaries, much easier than using classes of shares. We don't have to change the constitution or partnership agreement. We can just change the content of the trust deed if we have the power in it to do it. We don't have to change directors through resolutions and shareholders' votes. We just change them if the power exists in there. It's totally confidential because there's no register of trusts and nowhere are these trust deeds recorded. So we can pretty much do what we like, which is a real disadvantage if you are dealing with these trusts. And the corporate trustee arrangement, the trading trust, does protect the directors and shareholders, provided they simply act prudently as you would in any other company. And we've seen that with many companies. As long as you follow the right rules, there really isn't a great risk. And so we'll leave trusts there, and we'll just finish off with the sunset on trusts with a nice sunset from an island in the Okavango Delta, Botswana.